Good morning, ladies. Good afternoon, ladies and gentlemen. Thank you for joining us for the CDH webinar on the evolution of ADR amid litigation fatigue and COVID restrictions. You will be treated with a discussion from our esteemed colleagues from CDH in our dispute resolution practice, dealing with what has happened over the past several months in the development of an evolution of ADR, how practitioners and clients and users of ADR have adapted over the past years. So the intention is obviously to provide you with our insights, the depths during the depths of the pandemic, how technology has also assisted in ensuring that the wheels of justice continue to turn during the pandemic. So both, we give you a context from both a South African perspective or Southern African perspective on dispute resolution, ADR, mediation, arbitration, and court litigation, and an East Africa and Central African perspective. What I also want to mention, which is important as part of what CDH is doing as part of ensuring that technology is used more efficiently as part of arbitrations and alternative dispute resolution, is that CDH has joined a global campaign called Green Arbitrations, which is essentially a commitment to reduce our carbon footprint and going green across our business as part of the campaign called Green Arbitration. It involves a number of initiatives which we will also inform our clients in terms of what we are doing and what they can do to also assist in decarbonizing the globe through also utilizing ADR methodologies. So the program for today, and before I start in terms of introducing the speakers, please feel free to post questions on the chat box, which I will then pose to each of the individual speakers at the end of the presentation or their respective presentations, or if there's not enough time, at the end of the session where we will have an interactive discussion. There will be time for a general Q&A at the end of the session, as I mentioned. We will also be running a poll, so please feel free to use the voting tabs during the poll and complete. We will then share the results at the end of the webinar. It all relates to ADR specifically. Now to introduce our esteemed colleagues who will be presenting to you on ADR and the evolution and the changes that is happening in dispute resolution. So firstly is Belinda Scribber. She's a director in our dispute resolution department in Cape Town and a member of the Business Rescue Restructuring Insolvency Sector Group. She's also a qualified mediator, a member of the Mediation in Motion Institute in South Africa, and she has years of experience in dispute resolution, arbitration, mediation, and other alternative dispute resolution methodologies. Then next is our partner in the Kenya office, Desmond Odhiambo. He's a partner in Nairobi. He has over 10 years experience in providing dispute resolution, insolvency and regulatory services to clients in Kenya and various other African jurisdictions. He has represented clients in various complex arbitrations, whether ad hoc or institutional, and complex litigation. He has industry experience in both the banking, telecommunications, engineering and construction sector. And importantly for our discussion today, he is a qualified mediator and a member of the Chartered Institute of Arbitrators. Then last but not least is Tiffany Jechels. She's a senior associate in our dispute resolution department and has extensive experience in commercial litigation, arbitration proceedings, regulatory services spanning across the mining, energy and natural resources sectors. She's represented various clients, both private sector and public sector, expertise in public procurement and supply chain management, and has a specific interest in the petroleum industry, representing multinational oil and gas companies in various disputes that they are involved in. So to kick off our discussion today with insights on the development of mediation and the future of mediation in the Southern African region and other ADR methodologies, I will now hand over to our esteemed speaker, Belinda Scribber. Belinda, off to you.
Belinda, please unmute.
Apologies. Good afternoon, everyone. Thank you so much for joining us. My role today is to do a brief introduction into mediation because it's one of the lesser known alternative dispute resolution mechanisms. And I just want to give a brief introduction and then its applicability in Southern Africa, focusing mainly on court-annexed mediation, which I'll explain during the course of the presentation. So turning to mediation, I'm just going to put up my presentation quickly for you. Okay, mediation. So mediation it's a process that's controlled by a neutral party who doesn't make a decision on which party is right or wrong, and their role is to try and navigate the parties to find a resolution which is outside arbitration or mediation. It's so in order to settle the matter, or alternatively to narrow the issues down that are in mediation and arbitration. The advantage of that I'll explain a bit later, but the obvious advantage is that it will then narrow the issues to such an extent that it also limits the resources that will be required for the mediation, for the arbitration, sorry, or the litigation, if it ends up there. Reasons why people are starting to mediate a lot more is there are a lot of commercial disputes that are not actually ripe for litigation or arbitration in certain instances. An example of this is if you're doing a massive renewable energy project and there's a bespoke piece of equipment that needs to go into the project and you've entered into a contract with somebody and they have to make that piece of equipment, and for an alternative person to make that piece of equipment, you will have to, try and find somebody else, and it's difficult to do that, so it delays the project. So there's a lot of projects that are now becoming more and more accustomed to a possible mediation mechanism rather than an arbitration or a litigation mechanism, which is going to end up delaying the project long term until the dispute has been resolved. Another reason to go into mediation is to try and narrow the issues between the parties. When parties go into disputes, when they go into arbitration or litigation, they tend to try and throw everything but the kitchen sink at that litigation. And what ends up happening is each dispute then has to have its own resources thrown at it in order to resolve that dispute, to prove which party is right, which party is wrong, an expert on that specific dispute. So if you narrow down the disputes to what the actual issues are between the parties, then even if mediation doesn't lead to settlement between the parties, it can lead to a narrowing of disputes, and therefore it will allow the arbitration or litigation in court to go a lot quicker. A lot of parties are also experiencing what we're calling litigation fatigue. So they're realizing that arbitration and litigation takes a long time, and it can take up a lot of resources in terms of man hours and money and years before that specific dispute gets resolved. And therefore people are looking for alternatives to try and avoid the long drawn out mechanism of arbitration and litigation. So just giving a broad overview in terms of what is a dispute. A dispute is generally, and when it goes to arbitration or litigation, it's generally when there's been a complete breakdown of trust between the parties, and the parties are feeling betrayed by one another and they're not budging at all. Party A and Party B believe that they're right and they're not going to move from their positions. And that then ends up, in order to resolve the dispute, in order to get a landing on something, it ends up in the institution of legal proceedings, either through the courts or through arbitration mechanisms. And by that stage, the parties are so aggrieved with one another that our instructions generally are to throw everything but the kitchen sink, as I said before, at one another. So it's really, it becomes really disputed and it becomes really ugly, even in commercial disputes. So what happens is you end up in this long drawn out litigation dispute that costs a lot of resources, time, money, and one party may walk away with a satisfactory result. And the reason I say may walk away is because there are a lot of instances where the party that has been successful in the mediation or arbitration sometimes does not get what they want anyway out of the whole process. For example, if the party that they're disputing against has gone into liquidation, then they're ending up with an empty judgment and nothing that they can do with that judgment. So that's why a lot of people are looking more and more to alternatives to going on the full adversarial mediation and litigation route. So I thought the best way for me to illustrate the advantages of mediation is to talk about what most of us would have been through, and that's a personal relationship. So what you have is you have the introductions and sparks are flying, you go on dates, you realize you want to commit to one another, you negotiate how that commitment's going to work, and you tie the knot. Those many happy years, happy marriage all along, going on for many years, as I said. And then obviously in every relationship, there's going to start being differences of opinions. And sometimes those differences of opinions end up in disputes that are seemingly irresolvable. So then we end up with divorce. I think we're all, if we've not been through one, we're all accustomed to one, we've all been exposed to divorce. And then it's a splitting of the assets. How is the divorce going to, who's going to get what during the divorce? So then, because the parties are so aggrieved at that time, and because the disputes and emotions are running high, you're going to be spending a lot of resources on people like us, because you don't want the other person to have their wonderful green Lamborghini, or they don't want you to end up with your beloved Chancelange. So you would rather, at the end of your divorce, have an asset that's completely destroyed, as long as the other person does not get that asset. So how do we have an alternative to a disputed separation? When the elation of winning something you don't necessarily want, you realize how dissatisfied you are because you've got the Lamborghini instead of the other asset, and the other person's got an asset that they don't want instead of their Lamborghini. So we go to counselling. Mediation, counselling, that's something that's normal. People know about it in divorce proceedings, so it's something that's not new to family law. It's becoming more introduced to commercial law, and I'll explain why a little bit later. You go to mediation, counselling, and the counsellor tries to get the parties to calm the emotion down and to try and just see if there's a way that they can either come back to one another, which is sometimes it's very possible once you've managed to neutralize the emotions, or the alternative is to find an amicable way to separate so that there's the least damage caused possible to the entire family, and obviously also to the assets that are being distributed amongst the parties. So the question is then, is a personal relationship in marriage very dissimilar to a commercial relationship or a commercial marriage? Because what we have is, we have parties that want to enter into a relationship because they can see the benefits for one another in that relationship. They've met, they've seen the mutual benefit of entering into a relationship, they've done their due diligence, they're dating, they definitely want to enter into this relationship. So there's proposals that are made, they negotiate the terms of their relationship, they conclude their relationship, and they implement their relationship. And they start implementing the contract, and everything is going absolutely fine until it's not going fine. And there's a disagreement, and the disagreement escalates, and then the parties decide that the relationship is no longer commercially viable, and they either want to exit the relationship or they want to claim damages from each other, and there's a total breakdown in relationship. And then going back to the renewable energy example, what this will result in is it's going to be a delay in the project. It's going to have to find other parties that can possibly give you a bespoke piece of equipment that won't quite fit the project as you wanted it, but it's an alternative that you have to look into. So is there a way of trying to bring the original parties back together to get the project on the road and up and going again? In order to avoid, having to go through intense disputes, litigation or arbitration to decide who's right, who's wrong, who has to pay the damages, who was entitled, and all the while the project's being delayed. Again, you're spending an inordinate amount of resources on people like us in order for a judge to decide or an arbitrator to decide which party in the end is actually right or wrong. And after the elation of one party walking away feeling satisfied because they've won, they realize that the satisfaction is ill-gained because the project has been stalled and nothing is complete yet. So then introduce alternative dispute resolution, which is mediation, where you get a neutral party to try get the parties to sit down with one another and see what the dispute is, if we can get over the dispute, and if we can continue with the contractual relationship. There's a renegotiation. Resulting from the renegotiation is hopefully a reunion in order for the transaction to continue, in order to avoid long, extensive protracted litigation and/or arbitration. Or there's a commercially sensible separation. So it's a way of trying to avoid, instead of causing damage, maximum damage to one another, to try and avoid causing maximum damage to the transaction, to try and see if you can walk away from the transaction with the least scars on everybody. And I've given you the example of the renewable energy project. There are hundreds of other examples. If you've entered into a tender process, and in that tender process you are obliged to contract with a specific contractor, and now the two of you can't see eye to eye anymore, that whole process has to start over again, or you have to go through a whole lot of bureaucratic other hoops to try and change the contracting party, which causes delays and or a termination of the project. So the advantages, hopefully from this example, that you've realized is that mediation, its ultimate aim is to try and see if there can be a reunion between the parties. Alternatively, whittle down the disputes between the parties, highlight what the actual issues are, and then those issues go to mediation and arbitration. And by doing that, you're whittling down the resources that need to be thrown at the mediation, at the arbitration or the litigation. It's more cost effective because mediation shouldn't last more than 1 or 2 days. If after 2 days it hasn't resolved, it's unlikely to resolve through mediation. It's quicker for the same reasons, obviously. It's much more flexible, so parties are encouraged to think out of the box to see if they can find solutions to a problem that has arisen that's not necessarily within the contract, but then if they can find a solution, then it can be built into the contract as an example, as an addendum to the contract. This is a process that's completely confidential. So whatever happens in the mediation process is completely legally confidential. It cannot come out of there. It's without prejudice. The only thing that comes out of the mediation process that's not without prejudice is if there is an actual settlement agreement or an addendum to an agreement that's been reached. Then that's obviously not confidential, but everything that happened to reach that agreement is confidential. The other confidential aspect of it is that the mediator, when he's discussing things with certain parties outside of the room of the other parties, the mediator is not allowed to disclose those discussions unless the party who's having the discussion with him specifically authorizes him to have the discussion with the other party. So whatever's said between you and the mediator stays between you and the mediator unless you authorize otherwise. Okay, so I just want to deal with mediation in the legal realm, which is where we're going with this, is how is it viewed legally now in the legal sector? So we have private mediation and a court-annexed mediation or statutory mediation. Private mediation is when the parties agree to go to mediation without any encouragement from a third party. Sometimes it's built into your agreements. More and more regularly, it's getting built into your agreements. More parties are wanting it built into the agreement before arbitration and or litigation. So that's private mediation. Court-annexed mediation is our court rules are starting to evolve a lot more to encourage parties to go to mediation. There are some court rules that actually oblige parties to go to mediation, and I'll give some examples now when I'm going through the Southern African countries. Statutory mediation is mediation that's encouraged through certain pieces of legislation. For example, in South Africa, you've got the Companies Act, you've got the Labour Relations Act, which encourage mediation. Also, our Divorce Act encourages mediation. Some courts, non-compliance with the mediation process, some courts actually, there's a cost implication to that. I will go into it again in a bit more detail with some examples when I'm going through the Southern African countries. Mediation is not binding, as I said before. And everything, even if it's court annexed, everything that happens in the mediation process is completely confidential, and the parties cannot be bound by what happens in that process unless there is a formal agreement that's been reached after the process. In 2019, the UN actually opened up for signature the international settlement agreements resulting from Mediation Convention, and that was signed in August of 2019. 55 countries have signed it so far, and it has been internationally recognized as a convention which has now concreted mediation as an alternative dispute resolution mechanism for international disputes. Unfortunately, in Africa, only Eswatini has signed that agreement. That convention, and there are a lot of countries around the world, Europe, America, that haven't signed the convention, and it's hoping that it's just as a result of what's happening in the economy with COVID right now. This has just been put on the back burner, and hopefully when COVID is a distant memory, economically speaking, we will have more countries signing up to this convention. And then turning now to the Southern African countries, just to give you a taste of what's happening in those countries in terms of mediation and court-annexed mediation specifically. Eswatini, as I said, it signed up to this Singaporean convention for the UN. It doesn't yet have court-annexed mediation, but they are looking into it, and it is in certain pieces of their legislation. It's in the Industrial Relations Act, and they are looking to introduce it to other pieces of legislation. Then within South Africa, we have very recently been introduced to court-annexed mediation through our Rule 41A, and in terms also of our new case management rules. In South Africa, it's just something that has to be considered by the parties now. They have to file a notice to say whether or not they feel that mediation is appropriate. And if they don't, they just got to give a reason why in that notice why they don't feel that it's appropriate. If one party feels it's appropriate and another one doesn't, and the court decides at the end of the day that it was an appropriate mechanism and it should be considered, then there can be an adverse cost order issued against the party that did not agree to go to mediation. And in South Africa, our most well-known statutes, or our most common statutes that refer to mediation in them that are more commercially used, are our Companies Act and our Labour Relations Act. Lesotho does have court-annexed mediation. It is mandatory if a judge feels that if there's specific issues that the parties can take to mediation. There's also, if the judge doesn't make it mandatory, there's also a mechanism in there similar to South Africa where you can sign a notice as to why or why not you consider mediation as appropriate. If you don't sign that notice, there's an automatic assumption that you agree that mediation is a possible mechanism to be used as an alternative dispute resolution mechanism. In Namibia doesn't, its rules don't specifically just talk about mediation, they talk about alternative dispute resolution, which includes both arbitration and mediation. It's encouraged for parties to consider it, and there is no adverse cost implication, but there is a mechanism for a judge. If parties haven't opted into mediation, a judge can look at something and decide that a certain issue does need to go to mediation, and then it becomes mandatory. Again, it's in some of their statutes, their Labour Relations Act. Unlike South Africa, Namibia normally parallels a lot of our laws. What is not contained in their Companies Act is a mediation mechanism. It only refers to arbitration. Botswana.
Botswana. Note on time.
Thank you. Almost done. Thank you.
Thank you.
Thank you. In Botswana, there's an intention. It's not in their High Court rules, but they do have a commercial court, which is called the Industrial Court Rule, the Industrial Court, and it's a court that's been created out of their Trade Act, which governs certain commercial disputes. Again, the parties can agree, if they're going through that court procedure, they can agree to go to mediation, but a judge can also mandate mediation. So it can be compulsory if you're in the industrial court in Namibia. Zambia is probably one of the most progressive in terms of mediation. It's had a mediation mechanism since 1997. All disputes that are amiable to mediation have to be referred to mediation. There are certain exceptions, constitutional issues, liberty of individual, if a judge feels it's not suitable for mediation, or injunctions. If you fail to go to mediation when a judge has told you to mediation, you can have an adverse costs order against you, even if you're the successful party in that dispute. Zimbabwe doesn't have court-annexed mediation, but it is in their practice directives that they ask parties to at least consider it. So in their court practice directives, it is there. Then lastly, Mozambique, again, doesn't have court-annexed mediation. They do have an act that refers to that encourages mediation, conciliation, and arbitration. But to date, it seems that arbitration has been more the focus in terms of applying that act across their dispute resolution mechanisms. And that is the end of my presentation. Thank you,
Belinda. Very insightful in terms of mediation and the development of mediation over the past few years, and the usefulness actually of mediation in the resolution of commercial disputes also. And I think you've done a very good comparison in terms of looking at it from a family law perspective, and then how that actually can also work from a commercial perspective. Now, maybe just one question, and if we look at the polls, you might not have seen it. No. So the polls went out and we asked the question, which method, dispute resolution method, is preferred, and it was the option mediation arbitration. So the poll, 70% of people preferred mediation above arbitration and court action. So arbitration 21% and court action 8%. So a bigger preference for mediation as a means of dispute resolution.
It's good to hear.
And when we talk about mediation, Belinda, maybe just a question before we go to the next speaker. So there's always these multi-tiered clauses, and what is your view of, so you have negotiation, mediation, arbitration. So the preference, or should parties include such type of clauses in the agreements where there's a negotiation step and then a mediation step and then arbitration? What is your view?
I think if a dispute, if it's, I'm trying to say that if you go from a disagreement to a dispute, if there's a disagreement and it hasn't gone to a full-on dispute yet, then I think the parties can try and negotiate themselves to try and negotiate a resolution to that problem if it hasn't escalated. If it has escalated, then I think there's definitely room for mediation before arbitration. You have to look at what the actual issues of dispute are between the parties, and always remembering that what mediation is trying to do is to preserve the relationship between the parties. So in any contractual relationship, there's a reason why you entered into that relationship. There's a reason why you contracted with that person. So if you can save that relationship and avoid going to a full-on arbitration, then I would encourage trying to do that. It doesn't take a very long time. It's not very expensive. So I think these tiers are very good and they have their place. You just need to know when to use them and how to use them.
Yeah, definitely. Thank you, Belinda, for that insights. So we are almost at 2:30, so I'm going to go over to the next speaker, Desmond Obiambo. Desmond is from our Kenya office, and he will be talking about also mediation and ADR from an East Africa and Central Africa perspective. Desmond, over to you.
Thank you, Jacqua. Let me just quickly share my slide. Just please confirm you can see my slides.
Can see it. Thank you.
Okay, thank you. Thank you so much. Yes, so I'll be looking at mediation from the perspective of East and Central Africa. And just to give an overview, I'll look at the types of mediation practiced in these two regions. And then I'll look at the disputes commonly resolved in mediation. And I'll look at the qualifications of mediators in the region. And I'll do a comparative analysis just to for us to better understand to what extent has mediation been used in the various jurisdictions in Eastern Central Africa. And then I'll look at finally the impact of technology in light of the COVID pandemic and how that has impacted on mediation. So just to begin, so the types of mediation that are used in Eastern Central Africa, firstly is the court annexed mediation, which Belinda mentioned.
Yes, just sorry to interrupt. Your
yes.
slides, I think you're not moving down.
Okay.
It's still on the first slide.
It's still on the my side is showing.
I think we're not on the right screen, Desmond. Maybe share again.
Okay, sorry for that. Are you able to see?
Yeah, it's still on that. It's presenter mode, but we can see it.
Okay. Okay, that's fine. So the types of mediation that are practiced in Eastern Central Africa. The first is the court annexed mediation, which Belinda mentioned in her presentation, and we will discuss fully how it is applied in Eastern Central Africa. And then the second kind of mediation that is applied is traditional mediation, and then we have private mediation. Now, in the court annexed mediation, just to shed more light, so for specifically in East Africa, you find that this is a mediation process that is under the umbrella of the court, so it is supervised by the court. And what typically happens is that when parties file their cases, they go through a screening process. So the registrar looks at the case and sees whether it is appropriate for mediation. Most commercial cases that are appropriate for mediation, save in cases where the one party is seeking interim orders at the very outset. So in such a situation, then the case would proceed on to the judge to deal with the, with the interim orders, probably an injunction, or what in South Africa you would refer to as an interdiction. But where there is no such orders being sought, then the registrar is most likely to refer the matter to mediation. Now, the unique feature about the court annexed mediation in East Africa especially is that it is mandatory. Mandatory in the sense that once your case has been identified as suitable for mediation, then the parties are obliged to proceed before a mediator who's a neutral third party. It is not mandatory to reach an agreement during the mediation, but you must at least attempt the mediation once it has been referred there. And non-cooperation in the process may result in a penalty of costs when the matter, if they realize that you are not cooperative at all. Now, just to contrast with private mediation, under the private mediation, this is where parties privately resort to mediation. So it could be pursuant to a contractual clause. If you had a conflict resolution clause that provided for mediation, and you decide to invoke that clause so that your dispute goes before a mediator. Or it could be that when a dispute arises, you decide to approach an accredited mediator to resolve your dispute, and we'll be looking to see what an accredited mediator means. I hope you can see my next slide. So the disputes that are commonly resolved through mediation.
It's your next slide 3 is not moving, so I think if you can click on it.
Okay. Just let me know when it shows.
So if you, I think just click on 3, the slide 3, then maybe it will move easier manually.
Okay, manually. Okay.
That's fine. Thank you.
Okay. Sorry about that. So the disputes that are commonly resolved through mediation in East and Central Africa, we have commercial disputes. Now, this is through the court annexed mediation. So commercial disputes in Kenya, Uganda, and Tanzania, as well as Rwanda and Cameroon, they are resolved through the court annexed mediation. In Kenya, also family disputes are resolved through the court annexed mediation, and the statistics actually show that family disputes are the ones that are most have a higher success rate under the court annexed mediation. We also have labor disputes, land disputes, political disputes in Central Africa, particularly is where mediation has been used to resolve that disputes. And then we have in Rwanda, petty criminal offenses have also been resolved through mediation. Now, the types of the people who can act as mediators. So in Kenya, Uganda, Tanzania, and Rwanda, we have mediation accreditation bodies that set the standards, for qualification, for the education, and for the training of mediators. And the reason for this is because the desire is to have professional mediators who have a uniform way of approaching disputes, and which is particularly useful when it comes to commercial disputes. Then in the traditional mediation setups, of course, these are people who are elders, so they are not formally trained, but they are just appointed based on their integrity, and it is applied in varying degrees in the various countries. Then of interest also is in Uganda, Rwanda, and Tanzania, the judges and magistrates act as mediators, which is an interesting perspective, especially if you consider that mediation is private, and information is shared on a without prejudice basis. So it is interesting that in those particular jurisdictions, the judge has preview of is privy to information which may not necessarily be disclosed in an adversarial process when the matter actually, if the matter proceeds to litigation. So that's an interesting position. In Kenya, the judicial officers do not act as mediators. This is left to the mediation accreditation committee, which normally has mediators who are drawn from different professional bodies that have already undergone through the training of mediation. So just a comparison as to how mediation has been applied in the various jurisdictions. So in Kenya, Uganda, Tanzania, and Rwanda, we have court annexed mediation. And so which is mandatory in the sense that once your case is identified as suitable for mediation, when you have filed it in court, then you are obliged to proceed to mediation as a first step. But just as a reminder, it is not mandatory that you actually reach a settlement at the end of it. For Burundi, DRC, Central African Republic, Gabon, and Cameroon, there is no court annexed mediation as yet. It is still work in progress, and we also do not have a mediation accredited body that is responsible for setting the standards and for the responsible for just monitoring how mediation is conducted. So that is yet to be developed. There's still opportunity for that. Now, looking at technology, mediation and technology, considering the impact of COVID-19. When COVID, at the onset of COVID, at first people were resistant to conducting mediation online, and it took a while, for people just to adapt. And the reason for the hesitancy at the beginning was because one was, the lack of that personal touch. The mediator normally relies on reading the body language of the participants just to see how the mediation is going. So that is one of the reasons that caused the hesitancy at the beginning. But with the time, people now adapted and saw the silver lining. I would call the silver lining of COVID, where they saw the benefits of mediation. And one of the big benefits was that of online mediation was the cost savings. So a mediator, for instance, in Kenya would have to either use their own chambers to conduct the mediation, and if their own chambers is not adequate enough, because you need more than one room to be able to mediate effectively, then you would have to hire a physical venue. Now, with online mediation, you don't have to hire a venue, so that saves on costs, which ordinarily will be passed on to the parties. Then the other advantage was the flexibility in terms of time and convenience. You would be able to, now you can be able to hold the mediation at the convenience of the parties, and in terms of time and also the place where they would like to, log in from. So you don't have to convene at one particular place, which has encouraged actually more parties to participate in the mediation. And then there are still also some cons of online mediation. One is difference in time zones in situations where you have a party that is in a different continent, and there might be a challenge in agreeing on a suitable time. And then cybersecurity could affect the confidentiality of the process. Because the whole idea of mediation is that parties are encouraged to share without prejudice information, so confidentiality is really key. Then inability to read body language, we already touched on that, and then of course also varying degree of internet access can also be a limitation. And you might also find that some of the parties who decide just to be non-cooperative and can deliberately self-sabotage and claim that it was due to poor internet access that they were not able to participate in the mediation. Now, the impact of court-annexed mediation in Kenya, it has had great success since mediation began to be implemented. And the judiciary report of 2019 to 2020 showed that out of the 4,000 matters that were referred to mediation, 1,290 of them were settled, were actually settled at the end. And the economic impact is that about 7.3 billion, was saved by settling matters through mediation. The average time it took for those matters to be settled through mediation is 90 days. So which is very fast as compared to the traditional litigation, and even in some cases arbitration. So that is a really huge advantage. Some practical tips. Now, in situations where especially in countries like in the Central African countries, if you have a contract where one of the parties is in the Central African states, it is worthwhile to consider having a conflict resolution clause in your commercial contract, so that you take advantage or you guard against the risk of not having a mediation accreditation committee that you can refer to in those particular jurisdictions for purposes of resolving your dispute. So it is prudent to have a mediation clause in your contract, so that you can mitigate against that risk. And one of the things also that you can do at the contracting stage is actually nominate the institution that would be responsible for your panel of mediators you can choose from. An institution in South Africa, or you may choose the Nairobi Center of International Arbitration or the Kigali Center of International Arbitration for purposes of choosing a mediator. Yes, so that brings me to the end of my presentation. I welcome any questions. Thank you.
Thank you, Desmond. Again, very insightful in terms of what's happening in East Africa and Central Africa. And again, a big endorsement for mediation in various jurisdictions in East Africa as a means of resolving disputes or impasses and maintaining relationships. I think that's the fundamentals of mediation, in ensuring that you maintain long-term relationships. Then maybe there's any questions from the audience, please feel free to post it on the chat line. We will address it either at the end or during the session. For purposes, Tiffany, before you share, I have a question for Desmond. Desmond, in relation to mediation over the past few years, I would say 2-3 years, has really taken off as a means of resolving disputes, and you can see that in various countries, whether it's in South Africa and the Southern African region, as Belinda has set out, in the East Africa region. What about cross-border dispute resolution? So I know the preference is always arbitration because of the New York Convention and enforcement of arbitral awards. What is your view of dispute resolution or cross-border dispute resolution, commercial dispute resolution, and using mediation, where I sit in South Africa, you sit in Kenya, we sign the settlement agreement and you default? What is your view?
Yeah, that's a good question. Well, my view is once you have successfully gone through the mediation and you've actually signed the mediation agreement, that agreement becomes binding and it's enforceable just like any other contract. So you can take that mediation agreement and, for example, in the context of Kenya, just enforce it as if you'd enforce any other arbitral award, or enforce it as if you would enforce any other contract for that matter. So it is binding and it is enforceable. Yeah.
Okay. Thank you, Desmond. I think we're at the end of the discussion, we'll just have a discussion amongst all the panelists also about mediation, arbitration, and the interplay between the different forms of alternative dispute resolution, and obviously the courts ultimately. Thank you for your presentation, Desmond.
Thank you.
The next presenter will be Tiffany Chehals, and she will be unpacking the interplay between the courts and alternative dispute resolution, including the role of technology that we've seen over the past few months. Thank you, Tiffany.
Tiffany, please unmute.
There we go. Can you all see my screen?
We can see you, we can hear you.
Okay. So I will be dealing with how dispute resolution was impacted by COVID-19. Right, let me just see. So the obvious one is that the courts were immediately closed during the hard lockdown, which caused a backlog in the caseloads, and the courts were only entertaining urgent applications. Parties were then forced to consider alternative dispute resolution mechanisms, but they were obviously still faced with the issue of social distancing, which meant that parties needed to consider how technology will assist them in resolving their disputes. In order to do that, we made use of Caselines, Microsoft Teams, Zoom, and Skype. Starting off with Caselines, prior to the introduction of Caselines, and to a large extent is still applicable in South Africa because Caselines was only introduced in Pretoria and Cape Town and Johannesburg, the courts required us to physically issue the court papers at court. All the originals needed to be in the court files, which obviously resulted in accumulation of masses of paper and increased the risk of lost files. In Johannesburg, in order to open up a duplicate file, you needed to have 5 court stamps, which meant that you either needed to attend court for 5 consecutive days or 5 consecutive weeks before the court would accommodate you in opening up a duplicate file. For those of you who don't know what Caselines is, Caselines was introduced in Johannesburg and Pretoria during the 4th term of 2019, which is an online solution for the digitalization of court processes. This online system allows us to manage our pleadings and is obviously very secure. What would happen is you'll attend court to issue your hard copies. The court will create a folder for your particular matter. You will then upload your documents to Caselines and invite your opponents and your counsel to the Caselines folder. Only the parties that are invited to the folder will have access to your pleadings, and you can also restrict what the participants are able to do, whether they are able to invite other participants, upload documents or delete documents. It creates an audit trail, so you are able to keep track of when documents are uploaded or deleted, and there's a push notification. So every time your opponent uploads a particular document, you'll get an email with a link to the particular document, and you'll immediately know which documents were uploaded. It also dispenses with the pagination and indexing process, because immediately when you upload your document to Caselines, your document will be paginated. So this eliminates the trips of CAs and messengers having to attend court to paginate your court file. Parties then needed to use these online platforms in order to conduct the virtual hearings. Desmond already touched on the benefits of the virtual hearings, so I'll just briefly go through them again. The one being that it's cost effective, so you don't have to travel to another city or travel to court. You don't need to rent an arbitration venue, and most of these online platforms already have recording functionalities, so you don't need a transcriber to necessarily sit and record and transcribe these proceedings. It's expedited because it's easier to schedule. You avoid the need for parties to congregate at a specific location and time. The virtual hearings also decrease the reliance on hard copies because you can share the documents online or using your screen, such as OneDrive and Dropbox. This also speaks to the greener arbitrations that Jacqueline was previously referring to. The recordings are immediately available. Why I say this is a benefit is if you're running a 10-day arbitration and you're sitting and listening to the witnesses, you can make a note of exactly when the witness said a particular important point. After the day's hearing, you can go back to the recording and re-listen to that particular section without having to wait for these rolling transcripts, so it won't delay your preparation for the following day in order to effectively conduct your cross-examination. There's obviously challenges to these things, being the technical challenges and connectivity issues. And then often parties raise the issue of security and confidentiality of proceedings. I'll later address how these things can be addressed in order to ensure that they are confidential. Obviously, with Microsoft Teams as well as Zoom, you have the ability of creating a password, or you have to permit the participants as and when they join the proceedings. The other challenge, which was also raised by Desmond, is that the presiding officers and the counsel have an inability to read the body language. So witnesses during the virtual hearings, you can't see them, you only see them from the shoulder up, as you guys are seeing me, which poses challenges because you don't know what I'm doing with my hands or whether I'm reading my notes. How these challenges can be addressed is you can either appoint invigilators to be present at the venues where the witnesses are testifying. The judges should also ensure that the witnesses are alone in the room and that they don't have any notes with them. How you can do this? In a recent arbitration that I had, we had 2 cameras. We had one camera that showed the room, so we could see that the witness is in the venue by themselves, and the additional camera was facing the witness and their hands were on the table. So we knew that the witness was in the room by themselves, that they didn't have any notes with them, and no one could send them messages. If you are still unsure, but I think most of us have adapted now because we are in year 2, but the courts have been using Microsoft Teams, which we are all familiar with now, but the AFSA has published a remote hearing protocol, which gives you all these tips and tricks that I've given you previously about having 2 cameras, having the witnesses place their hands on the table. The Africa Arbitration Academy has also published an protocol, which is very similar to the protocol of AFSA, which gives you the tips and tricks to make sure that these hearings are effective. There's also the tribunals like the National Consumer Tribunal. They are making use of Microsoft Teams to conduct their hearings, but they have published their own manual to assist the participants in using Microsoft Teams, and the SCA has published a similar manual per se for Microsoft Teams to assist parties to effectively use this platform. Now the question is, can we have mediation, arbitration, and litigation coexist? The short answer to that is yes. Negotiation and mediation can obviously always play a part in arbitration and litigation, but arbitration and litigation are mutually exclusive, so these two cannot coexist. Where you see parties are heading is the introduction of contractual obligations in their contracts that require you to either negotiate or mediate before you go to arbitration. I saw one of our participants has posted a question about this. Here's an example of where parties in the agreement require you to either negotiate or mediate before the time. In this contract, it requires the parties to create a special committee where there'll be a managing director from party A and the CEO of party B. They'll try and resolve the dispute, and if the dispute is not resolved within 30 days, then the matter will go to arbitration. Another example is the joint committee, where there'll be a director or party from either side who will form this joint committee. They'll try and resolve the dispute within 14 days. If they don't resolve it within 14 days, they'll go to arbitration. Or you can have a hybrid of this, which is the following example, where you first say that the parties must negotiate. This will be the vice president or senior management representative. If they can't resolve the dispute within 20 days, then you can refer the dispute to mediation, and you can, in your agreement, stipulate how this mediation will be conducted. In this example, the mediation will be facilitated by AFSA, and only after both these steps have been exhausted will a party be entitled to go to court or go to arbitration. Obviously, this doesn't eliminate the party's right to go to court on an urgent basis if they need an interdict. But these are the examples or mechanisms in which parties can force their opponents to negotiate, mediate before arbitration or before going to court. The courts have also now introduced a mandatory mediation process in terms of Rule 41A. So in terms of Rule 41A, parties now to a new action or new application must, together with their application or their summons, file a notice stipulating whether or not they are amenable to refer the dispute to mediation. Their notice must, however, clearly stipulate why they believe the dispute can be resolved by mediation or why they are opposed to mediation. This mediation process will be without prejudice, and it's not filed with the registrar unless we face the cost issues that Belinda touched on previously. The ways in which this mediation can be conducted is the parties can either agree that the dispute be referred to arbitration after the application was issued or after the summons was issued. However, if the trial or the opposed application has already commenced, so if the hearing has already started, you'll need leave from the court to refer it to mediation. The judge, or if your matter is under case management, they can also refer it to mediation. If the parties inevitably decide that they want to give mediation a shot, they'll sign a joint minute and they'll enter into a mediation agreement where they'll set out, obviously, the issues that needs to be resolved by mediation. Nothing precludes a party from also setting out, if there's 5 issues in dispute, they can refer 3 of those issues to mediation and keep the 5 for the court to determine in order to reduce the number of disputes that the judge needs to deal with. One of the benefits of this is while the parties are trying to mediate, the prescribed time periods for the filing of their plea or their answering affidavit will be suspended until the mediation is finalized. However, this mediation process must be concluded within a 30-day period, which seems to be the standard time period allocated for these mediation processes. During the lockdown, there was obviously this fear of the unknown. So certain courts, from my experience, didn't adopt this virtual hearing process. The courts were closed and you had to appear in person. In Limpopo, for example, they weren't permitting virtual hearings, and I was required to appear in person or I ran the risk of my matter being removed from the roll. And obviously you have to choose the greater of 2 evils. You have to attend because you don't know when the next hearing dates will become available given the backlog that the court was experiencing. In KZN, even now in 2021, there's limited virtual hearings and it will be within the judge's discretion. So only once you know which judge is allocated to your matter will you have an indication as to whether or not the court will permit virtual hearings. In Botswana, the same thing was applicable. You have to appear in person. In Botswana, however, litigants were more inclined to agree to arbitration proceedings to be conducted virtually. An example of this is during the hard lockdown. I had a contractual dispute in the petroleum industry where we needed an expert determination. I was sitting in Johannesburg, my opponent was in Botswana. We agreed to the appointment of an expert from the Johannesburg bar. We exchanged papers and within 2 weeks I had an expert determination and the dispute was resolved. So that's how effective the virtual hearings are, but you obviously have to have an opponent that is amenable to this. In the Eastern Cape, virtual hearings, again, very limited within the judge's discretion. In Lesotho, the courts are not permitting virtual hearings. In actual fact, they've only introduced a manual in March this year, which they've only started implementing in May, where they'll permit virtual hearings, but to a very limited extent, and this is the exception rather than the norm. They also have mediation in terms of their court rules, similar to our Rule 41A. Arbitrations, however, very uncommon. Parties are very reluctant to enter into arbitration agreements in Lesotho from my experience. But I think part of that, again, is the fear of the unknown. Although they have an arbitration act, they don't have the necessary structures in place to facilitate these arbitrations, such as AFSA. So parties are more inclined to go to court. And I think that's the end of my presentation.
Thank you, Tiffany. for your insights on what is happening in the different jurisdictions, specifically, I think from a virtual hearing perspective, and how different, even within the same country, South Africa, you have different provinces adopting different methodologies, and also examples in terms of what's happening in Lesotho and in Botswana in terms of the practitioners are more open to arbitration or virtual arbitrations as opposed to where the courts are very reluctant to entertain virtual platforms for dispute resolution. So I think we're now at 3:05, and there's a few questions that has come through. And maybe the first question, Tiffany, I think all the panel members can probably, or presenters can put on their videos, Desmond. So the audience have asked a few questions. Let me just quickly get that. Sorry. Hopefully everyone has enjoyed the session so far. So one of the first questions, I think this is addressed specifically for Desmond, and it relates to cost of mediation. What are the costs of mediation in East and Central Africa? Do parties share the cost? Desmond?
Yes. So for court-annexed mediation, if you're referring to costs as to the costs incurred by the mediator, for the court-annexed mediation, the parties don't have to pay anything extra as long as you paid the filing fees when you filed the case at the onset. Then there's no additional cost for going into mediation. Now, where it is an institutional mediation, or rather, what I mean by that is where it is supervised by an institution other than the court in a private mediation, such as the Nairobi Center of International Mediation, then those institutions set up the costs. So, for example, for the Nairobi Center, you would find that they would set up, it would be 10,000 shillings for initiating the mediation process, and then for the first three hours, it's 15,000, and then 5,000 every hour after that, and the cost is shared by the parties in such situations. Yes, so the short answer is for mediations that are supervised by institutions, the costs are shared by the parties, and it will vary depending on what have been determined by those institutions.
Thank you, Desmond. Maybe a similar question. So that was a question from Tando. Thank you for the question, Tando. Similar question maybe to Belinda. In your experience, South Africa, the cost implication for court-annexed mediation and in a private mediation where parties just agree to mediate?
There's no distinction between, when it comes to the cost, there's no distinction between private and court-annexed. It goes to a mediator and you pay the mediator's costs. Costs vary, so a mediator per day is between, I'd say, 2,500 and 10,000 a day, depending on who you use as a mediator and how experienced they are. And mediations do not normally last more than 2 days. As I said, parties generally know within the first 2 days, or mediators generally know within the first 2 days whether something is going to be able to be resolved through mediation. So the costs probably maximum between 20 and 30,000, maybe.
Split between the parties, the cost of the mediation.
Between the parties, yeah, unless there's an agreement otherwise.
Okay. Belinda, and I think this is another question for you specifically. Tiffany can also interject if she wants to. So the question is from Tosh Naidu. How far are we in making mediation part of legislation? And take, for example, the National Credit Act. The debt review is court-mandated process, but often clients cannot afford the opposition by credit providers. Mediation seems like a more effective way to resolve the disputes that have arisen prior to approaching the court. What's your views?
I think this is where it's very advantageous that our new rules have come in, our rules of court. because Rule 41 specifically states that when a party institutes legal proceedings and when a party defends legal proceedings, they've got to say whether or not they feel whether mediation is appropriate or not. And if you're defending a matter and you feel that it is appropriate for mediation and you file that notice, then the other party has the risk, if they don't go to mediation, they run the risk of, even if they're successful against you, they then run the risk of an adverse costs order against themselves for not going to mediation if a judge feels that mediation would have been appropriate. In terms of the costs leading up, there are mechanisms available. There's legal aid, and also there's the case management provisions of our court rules now. So you, as the defendant, can actually ask a judge to case manage something, and a judge can then encourage mediation to the parties. And I think a credit provider would probably be very risk adverse to not going to mediation if a party's sitting in front of a judge saying, I would like to go to mediation, and the judge is saying, I think it's appropriate to try and go to mediation. So there are ways of trying to push the boundaries.
And maybe just a follow-on question, with the introduction of Rule 41A, it seems, and that's maybe a big problem with attorneys, where attorneys do not prefer mediation, but it's more the clients would prefer mediation, and attorneys usually advise the clients, okay, don't mediate, go and litigate. What is maybe Tiffany's view, and then Belinda, you can give me your views also.
100%, Jackwell. So since this rule has been implemented, I can say nearly every single application or summons I received, the attorney says not capable of being resolved by mediation because it will delay the proceedings. So I do think that attorneys need to adopt a conservative approach when it comes to this mediation and seriously consider it. Obviously, we often, as attorneys, hold the view that once the client comes to us, they would have exhausted all these remedies. However, I think with Rule 41, attorneys need to be more open to the mediation process. It's there for a reason. And like Belinda has indicated, if you're the party that is opposed to mediation, you potentially in for the cost order. So that should deter attorneys from just saying no. But even if both attorneys says no, often you get to case management, or the judge assigned to the matter will send you away and your matter won't proceed on your hearing date because they encourage you to mediate. So I do think this is one of those things where the attorneys need to start becoming more conservative in adopting this Rule 41A approach.
Yeah, no, definitely. I think the attorneys feel excluded, or it's issues of we're not going to get our fees, but it's not really about the attorneys, it's about the client to try and find a resolution for the dispute. Belinda, what's your view?
I think if you speak to most experienced mediators, they will actually want the involvement of the attorneys anyway, because clients will always want to seek an attorney's advice on something. So attorneys can actually help settle disputes. And if it does end up in a settlement agreement at the end of the day, the attorneys are going to have to be there to try and draft that settlement agreement so that when the parties walk away, they've actually got an agreement at hand, instead of just an agreement to agree, which we all know can also, tear it up as you walk out the arbitration room. So there is room for attorneys in mediation, and I think attorneys need to just embrace that. And clients are always going to be more appreciative of attorneys that find them a quick, cost-effective resolution to something than dragging them through unnecessary arbitration and litigation. That being said, there are some disputes that are just impossible to resolve through mediation. So there will always be matters that go for arbitration and mediation. But if you're an attorney, I think that a client can trust that you're making the right call for them as to whether to go the hard route or whether to try the softer mediation route. Then that client is always going to come back to you, rather than if you're just encouraging litigation when it's not always necessary. And also, I mean, we didn't touch on the magistrate court's rules, but the magistrates are very, very strict now, and they're actually starting to issue adverse cost orders against attorneys if attorneys haven't encouraged and advised their clients of mediation before they go to trial.
Yeah, and that's ultimately, we need to deal with the backlog in the court system, and there's much more efficient ways of resolving disputes, even though, again, the attorneys think they are being attacked through utilizing mediation being excluded, but as you point out, mediation, there is a role for attorneys to support the process, advise the clients. It's a client-driven process where the clients must take the lead, but the attorneys must advise on whatever legal risk and issues and draft the settlement. So definitely. Jasmine, what is your experience in Kenya in relation to the attorneys' involvement and the clients, and also the push for either going to arbitration or mediation?
Yes, thanks. So we've had similar experience to what you've had in South Africa. So we have a section of advocates that are resistant, towards mediation. So they will not cooperate. And we have another section of advocates who are pro-mediation and are pro-dispute resolution, irrespective of the method that is used to resolve that dispute. So it's a question of awareness. I think for advocates, it's also, just realizing that what is available through the process of mediation is far much wider than what you'd have in a traditional court litigation or arbitration, in terms of the options that you have to resolve that dispute. And I think also at the end of the day, it benefits both the practitioner and the client if a matter is resolved speedily. Yeah. So I think it's just a question of time. We have to keep on sensitizing both the practitioners and the clients on the benefits of mediation. Yeah.
And that touches maybe on the next question, and it's a question that was asked by Rikus Kiepers. And it's a very important question because that's ultimately what clients wants to know. So I embark on this entire mediation process. Yes, it's cost effective, it's efficient, but then it still costs me money down the line. So his question is, the issue we see with enforcing mediation clauses is that you sometimes have to run to court for an order to enforce those clauses. That is not a good start to any form of mediation and defeats the purpose of mediation, the mediation clause before the mediation process starts. So I think he's talking more about the initiation of the dispute through mediation, but there's also maybe what I want you to address is, now I've done the mediation, I'm completed the mediation, I have a settlement agreement, and I still need to enforce that. Is that a negative to mediation as a process, or can we come around it? Maybe the first, Belinda, you can answer that and see.
Yeah, I think if parties are going into mediation with the spirit of resolving something, then the settlement they reach, they've reached a settlement again for a reason, because they don't want to go into dispute, into long protracted litigation or arbitration. So I think you'll find that parties will try and enforce that and fulfill their obligations under that agreement. But if they don't, then what the mediation has done is it's actually whittled down what the issues in dispute are into now what is in that settlement agreement. So instead of having a wide array of disputes that you need to prove, you've now got very, very narrow disputes that you need to prove, which then again it brings your costs down. It brings the amount of days that you need to be in arbitration or in court, because you're only focusing on one or two issues instead of a whole lot. So hopefully parties will stick to the settlement agreement in order to preserve the contractual relationship, because that's ultimately what you're trying to do. But if you don't, then your settlement agreement has whittled down a lot of those issues, and that is definitely, you can go to court to enforce that settlement agreement. What else you can do is if you're already in mediation or in litigation, in litigation or in arbitration, is you can get that settlement agreement immediately made an order of court. You can agree to do that. So if somebody does breach, they're immediately in contempt of that order, and you can start actually the execution process as if that settlement agreement was a judgment.
And would the current rule, the rule 41, so if someone initiated action against another party, and there is a mediation, so you can use that process to then make that settlement agreement order of court.
Absolutely, yeah.
Which makes it more efficient. Desmond, what is your view?
Yes, I would agree with Belinda, and especially with the court annexed mediation, you have room to use that settlement agreement as a court order, and so if it is breached, then you can just enforce it just like any other court order. So it's not a disadvantage for going on to mediation, even if the one of the parties does not hold up to the mediation agreement. And then maybe also just something else is also, at the end of the mediation process is that you find that you are able to reach a resolution that you would normally not be available, for instance, in the contract, in the original dispute itself. Because in a normal contractual dispute, a judge is limited by looking at the rights under that contract. But in a mediation, you may find a resolution that is outside that contract. So it even could be, an agreement on another contract by itself. So once you reach that agreement, even if it is breached, you're in a better position than you were in, at the beginning of the dispute.
Definitely, yeah. So there's various mechanisms that you can deal with that. But when we talk about, and we talk mostly now from a domestic law perspective, where you have, say, two parties in Kenya or in South Africa that is involved in this mediation. You make it an order of court. The enforcement of a mediation award, and I've mentioned it, or not award, a mediation agreement, a settlement agreement pursuant to a mediation in another jurisdiction. So Belinda mentioned the convention, mediation convention, or more popularly known as the Singapore Convention. So there's 55 signatory states, and I think 7 of those states have ratified it. There's only one African state that has to date actually signed it. None have ratified it. What does that actually indicate to us as legal practitioners and to the users of mediation from a cross-border dispute perspective of the state's endorsement of mediation for the resolution of commercial disputes, whether a party in South Africa and Kenya who have a dispute and use this mediation? What does that say, broadly speaking, about the state's endorsement of mediation on an international level? Maybe I can start with Desmond and then Tiffany. Yeah,
I think what it means is that there needs to be more sensitization to the state actors on the benefits of mediation for international commercial disputes, and especially if you look at the increase of regional trade, it is something that needs to be looked at quite keenly, so that there is a mechanism also that many more African countries can be part of that treaty. And sign up and ratify to it. So I think sensitization, should be done.
Yeah, definitely. Tiffany?
I agree with Desmond. I think often we all view mediation as a swear word or something that we shouldn't do. If we realize that it works, and I think in order to demonstrate this, for more parties to buy into it, we need to do it and demonstrate that these mediation agreements are enforceable and that it does work. If not, if we're all trying to avoid mediation, no one is going to buy into it. So I do think that Desmond is spot on by saying there needs to be a buy-in from more states into these things in order for us to implement it effectively.
Thank you, Tiffany. Belinda, what is your view?
I think, as I said at the end of my presentation, I think it might be that the reason that a lot of countries haven't yet signed and or ratified the Singapore Convention is just because this world's gone into chaos in the last 2 years, and I think countries are just trying to manage the economic environment that is, immediate, that calls for immediate resolution at the moment and immediate problem solving. And I think after that, we're going to see more countries signing up to it. For example, out of all the Southern African countries that we've mentioned that have courts annexed mediation, there's obviously a state buy-in to mediation. And I think once they're given an opportunity post-economic COVID, I think you'll see more countries signing up to it.
Yeah, no, definitely. I think there's a big traction to do that because the Mediation Convention is seen as similar to the New York Convention. So the more states sign up for it, the more people or international parties will utilize mediation as a means of cross-border dispute resolution, which is more cost effective for the actual users, not for us as the lawyers, but for the users of the method. So we have 4 minutes left. So any final words for our audience on ADR? Maybe start with Belinda.
Yeah, I think it's an exciting time because there's some silver linings to COVID. I think one of the silver linings is we've been forced to go more electronic and more digital, and we're seeing the advantages of that. Another is, as Tiffany was saying, a lot more people are buying into alternative dispute resolution. At the moment, I think arbitration seems to be the favored child, but as people are getting more and more fatigued by exorbitant dispute resolution costs, and not just costs, but the resources. You've got to take man hours out. It takes a lot of energy to go through an intense dispute. And I think as people start evolving more to want to settle things and are more involved in these huge cross-border transactional relationships, as I was saying, and you want to retain those relationships, they're going to start buying more into alternative dispute resolution that tries to still bring the parties together and find a way that the parties can still remain in the relationship.
Definitely. Thank you, Belinda. Desmond?
Yes, there's the future for mediation is bright. I think there's a great opportunity for parties to resolve their commercial disputes, especially through the use of mediation, and even for the parties, the more and more parties are aware about the advantages of mediation, then they are also better prepared for the process itself. So it's not just a question of the party sitting back in the mediation process and telling the lawyer, you do all the speaking. They have to play an active role in that process and actually prepare for it and know what it is that they would like to get out of it. But of course, keeping an open mind. Yeah. So,
indeed.
Thanks.
Thank you, Desmond. And indeed, that's important. Tiffany, last words.
My last words is just that I hope that this presentation was informative and that we encourage the participants and our clients who attended to consider the mediation process more carefully, as opposed to being obstructive or less inclined to do mediation, and to demonstrate the effectiveness of virtual hearings, which will save cost and expedite litigation proceedings.
Yeah, well, thank you, Tiffany. And we're 2 minutes left, and thank you to our audience for joining us for this hour-and-a-half session on ADR technology and what has happened during the COVID lockdown and how we've actually sharpened our tools to use ADR more effective in resolving disputes and saving costs for clients. So hopefully it was insightful. We will arrange other sessions again where we can talk about maybe mediation in a bit more detail and also other forms of dispute resolution. But thank you again and enjoy your afternoon. Bye-bye.